Okay, I wanted to take just a minute to give you sort of a special education 101 lesson on referral meetings. And that would be for you parents that, your child doesn't have an IEP yet. You are in that very beginning stage. And I'm not talking about those of you that have an IEP that are, let's say, in a reevaluation process. This is the very, very beginning part of the process, still within the confines of what we call the child find mandate. And child find, in short, is that the school system has a legal responsibility to locate children within their geographic boundaries that might have a qualifying disability and be in need of specialized instruction. Now, as far as locate, once they locate, then they have a responsibility to convene a referral meeting and potentially evaluate in order to see if that child does in fact have a qualifying disability and is in need of specialized instruction, which is special education. Now, locate means what? Well, that it could be transient individuals, those that are homeless, those that are homeschooled, go to a private school. It just doesn't matter. That is any child within the geographic boundaries of the public school system that may have a qualifying disability and be in need of specialized instruction. Now you sit there and you go, well, if my child is homeschooled or private schooled, then it doesn't matter, guys. You don't have to enroll your child in order for the school district to move forward with their mandate to locate and identify those children who may need those services. And so what that means is that you can sit there and let's say be homeschooling your child or be in a private school and still approach the public school and say, look, I think my child might have a qualifying disability and may need special education services. At that point, the school system has that responsibility to go through that process and see if that evaluation is warranted. Let's say they go through the evaluation process and yes, that is determined through the evaluations that the child does in fact have a qualifying disability and would benefit from special education services. It is at that point that the school system has to, or the parent, more or less, the parent at that point then needs to make a choice. Okay, am I going to continue to homeschool or continue to private school? Or am I going to enroll my child in the public education system if you live in a state where, you're not entitled to any kind of collaborative kind of sharing with regards to special education in a homeschool environment? Most states don't allow that in homeschool settings. There is some mechanisms to have some contribution or some services within or maintaining a private school placement, but most of the time it's going to be the school system says, hey, your child is eligible and we can offer your child these services, but it would require your consent in order to have the school district move forward with those services. And most of the time that consent is going to be attached to the condition of you enrolling your child inside the public education system. Okay? Now, if you choose not to do that, then don't consent. And then at least you know that your child does require these type of services, that they have identified your child. But that is the child find mandate. Okay, just because they evaluate your child doesn't mean that you have to sit there and rip them out of their placement to put them in the public school system. That doesn't happen until after the evaluations are done, and identification for special education services are made, and then they present you with the option to consent to those services or not. Okay, now I have a case that we're about to start, and I just sort of got me thinking about doing this, and I wanted to throw this up there and sort of give you an example of what is, let's say, a child find mandate when a child is enrolled and attending within the school. And let's say the child has a 504 plan, or let's say the child is on RTI, which is the response intervention process, and they're just sort of cycling. And let's say the parent says, look, I think that this isn't working. The 504 isn't working. RTI isn't going anywhere. My child is still sort of spinning their wheels or regressing. We're not making any ground. I think my child requires special education services, and makes that request to the school system. Well, at that point, guys, in this situation, what ends up happening is that this is a meeting notice, for example, and if you notice up at the top left corner where you have all the boxes over here, you'll see that the box determine if referral requires evaluation. All right. Now let's start there. A referral meeting cannot be denied to a parent. A parent can, ask for a referral meeting. That is a big no-no for a school. You've got to have the referral meeting. Where a lot of parents get confused is that just because you're in a referral meeting doesn't necessarily mean that the school district is going to agree to move on to the next step to get your consent to even start the evaluation process. The referral meeting is the guarantee. What isn't the guarantee is whether or not the school district believes that sufficient need is there to get your consent in order to answer that question, the million-dollar question of whether or not your child has a qualifying disability and is in need of specialized instruction. Okay, so this is the meeting notice, which means that the school system did in fact comply with the request for a referral meeting. Okay, so they did comply with that. Now, what I want to point out in this is this aspect. All right, this was the result of the meeting. So if you noticed that their concerns, that the mom had concerns about the medical diagnosis, side effects it has on his ability to come to school. I did redact, any kind of identifying information. But quite frankly, the concerns, the school district sort of notated it in a way that they were comfortable with. That isn't the reason that the parent was coming. That's partially the reason. But with regards to the 504 plan, because I'm about to start this case, they're accommodating the kid to death. And there is a way to mask a child's academic deficits if a school system is clever in how they over-accommodate. And if they can over-accommodate, then the school system says, well, he's an AB student. His grades are too high for an IEP. Guys, whether a child progresses year to year has absolutely nothing to do with whether or not the child requires specialized instruction. It says that in the law. A child could be progressing year to year and still require an IEP. And so in this particular case, the reason that the school system is going to be in trouble is that they decided not to move forward. If you look right here, they decided not to proceed with testing and just make revisions to the 504, which they've already done in the past. That's where they screwed up, because I believe that sufficient evidence exists and sufficient information exists to where they should have just ruled it out. And this is where a lot of schools get themselves in trouble. They may have the referral meeting, but it is almost better to err on the side of caution and go ahead and complete an evaluation process in order to safeguard yourself from the possibility that the kid does in fact qualify. And if the kid does in fact qualify, now I have evidence dating back to January that you knew you should have moved forward with evaluations. You didn't move forward with evaluations. So therefore, now my client is entitled to compensatory education dating back to that time when the district should have suspected, known that the child was in fact a child in need of specialized instruction and had a qualifying disability. And in this particular situation, after reviewing everything, they shouldn't have made that decision. They should have gone ahead and evaluated. And so what we're going to do for the parent is that we're going to fix the 504 accommodations so that we're removing the negative accommodations that are masking his academic deficits Okay, we are going to put the proper mechanisms and accommodations in place in the interim of them completing the evaluation process. And I'm going to ask that they expedite the evaluation process, which may, they have by law 60 days from the point that the parent signs consent. But, sometimes we can negotiate that they speed up that process because it is burning the child's academic time during the school year. But at the end of the day, that's just me asking nicely to see if they can do that. But a school does by law have 60 days to complete the evaluations. And then after they complete the evaluations, they have 30 days from that point to even convene an eligibility meeting. So, and then once they make the determination of eligibility, they have another 30 days to develop the IEP. So you see where potentially a school system, if they really wanted to be jerks about it, could burn all 60 days, could burn another 29 days, and then burn another 29 days, or another 30 and another 30 before your child ever sees an IEP. And that is 4 full months, almost half of a year. So, I don't want to get into the negative. I have seen that happen. Most of the time, that isn't what happens. But I wanted to sit there and walk you guys through that a school must do a referral meeting, okay? Must do a referral meeting. Cannot deny you a referral meeting. Doesn't necessarily mean that you're going to get to that next step of having the school system agree to get your consent to start the evaluation process. If sufficient information is there for a suspicion, then school system should err on the side of caution. Go ahead and do a thorough and complete evaluation because that further insulates them from a legal suit, due process, for example, and exposure on the legal side by just checking those boxes off. It's just sort of the smarter way to do things. That school didn't do it the smart way, especially with what I've seen in how they've over-accommodated the student in a very clever way to mask the academic deficits. And don't ever, ever, ever as a parent or as a school system tie a child's need for special education services off of grades, arbitrary grades at that. Especially if your child is being accommodated in those grades, because that's not a true snapshot of what's going on. Okay, because if you were to remove those accommodations, your child would not be making A's and B's. All right. So schools should not be tying a determination on whether a child requires an IEP off of grades. Bad. Why is that? Because grades are nowhere in the eligibility criteria, guys. None of the 13 categories for which they will, evaluate your child against to see if your child requires an IEP. None of those say, what are the grades? It just isn't in there. We use cognitive testing. We use behavior and adaptive rating scales. We use observations in structured and unstructured environments. We do achievement tests. We look at environment. There's a whole slew of things we look at depending on the category. Grades aren't part of it, because those things can be arbitrary. Okay. That was my little lesson for the day.